I asked the question of our esteemed chairman if he just decided to have the senior members work together and discuss this. And he remained good and quiet during the time. All right. Ms. Brooks, I enjoyed our conversation.
I did too, very much. Put me at ease.
Actually, it was an extremely enlightening time that sometimes you get that on this commission, and if you can't tell, I'm sort of organizing over here. And I did warn you that it's horrible having to be the person on the break and then come back, did I not?
Yes.
Okay. However, I did want to say right off the bat that I enjoyed going through your application or discussions because you're sort of what I would call that blue collar type of background. And if you would you take a minute or two just to sort of, and I'll keep calling you Miss Brooks instead of Jamie like we did when we were talking, but would you just give us, just walk through how you started and how you ended up over here?
Okay. Well, Mr. Lawless and the commission, I grew up in Nashville. Was born there in 1959, and you were talking about Baptist in St. Thomas. I believe I was born in Baptist Hospital downtown. Went through school there, entered Trevecca Nazarene University in 1977, and like some folks, I was able to cram 4 years of college into 5. But the benefit of that was I met my wife, Carol, and we started dating in about 1980, and we got married just after the first year of law school in '83. As I went through law school, and a lot of you will know this if you went to UT, your world is defined by your last name, A through H. That was my world when I was in law school. Fell in with some really good folks in my study group from East Tennessee, Elizabeth Asbury, Robert Eastep, or a couple of them. And of course they saved my bacon more than one time in class. But when we got towards the time of graduation in '85, I had a choice. I could go back to Nashville and I was going to do insurance defense, or my wife wanted to stay in East Tennessee because her sister's in Maryville. And so I had a buddy, Bill Cooper from Oneida, that said, hey, you need to come interview with Phillips and Wilson, and that was the name of the firm at that time. It was Tom Phillips in Oneida and James Frank Wilson in Fort Worth. And so I did, and they took a chance on me. My former partner's here today, and was a great mentor to me, as was Tom. And so I started in August of '85, didn't know if it'd last 6 days, 6 weeks, 6 months, and it's been over 37 years. I tell folks I'm kind of a man without a country because I've live in Oak Ridge. I've lived here for 38 years. My office is in Morgan County. I'll come back and we'll talk a little bit more about that in just a minute, but could never see myself being a judge out there because I don't live there. But I have kind of privately entertained a desire, and I thought about it briefly 8 years ago, or 9 years ago now, when there was an open seat here. Timing wasn't right. Never would have dreamed there would have been an opening within months of the election. Timing felt right, so I applied, and here I am. Now, you mentioned blue collar, Mr. Lawless. You being in a rural area like I am, which is sort of at the conjunction of about, I'm going to say 10 counties, but 3 judicial districts. You take Knox out, there's 9, and 8 of them circle Anderson County. That's the 8th judicial district, and the 9th judicial district, and then the 7th. And I've just traveled around in all these districts, primarily, not exclusively, but primarily in Chancery Court. That's what I've done from the get-go. Domestic relations of all manner, from name changes to terminations to adoptions to complicated divorces. We do, in our practice, is all kinds of land matters. That's always historically been 40–45% of what we do. Within that is transactional, but it's also litigation. And then, of course, the probate side of it. Now, that's the Chancery Court aspect of it. And I've looked, in those percentages, in our district, where I primarily have practiced, the 9th, and the percentages in the 7th district, at least in Chancery Court, are almost identical. I think it's about 70% domestic, probably 10 to 15% probate, and a little bit less real property, and then other kinds of things thrown into it. And that's what I've done for 37 years. I feel very, very comfortable with the law. Now, I don't know everything, none of us do, and I have counted on, we were talking about mentoring earlier. I was mentored very well coming up. Like I said, my former partner's here today, and he mentored me. Judge Elledge, he may not realize it, but there were times back in the 20th century when he was still practicing, and we would wind up on the opposite sides of cases. He was very kind and gracious to me when he could have nailed my hind end, or he would pull me aside and give me some advice. More recently, Mr. Bobo, he's been, because workers' comp has kind of gone administrative and I don't do very much of it, he's kind of been of a go-to person if I have a workers' comp question. So the mentoring has helped me, I guess, be comfortable with the forms of practice I have. And like I said, whether we realize it or not, we're mentors. We're either mentoring or we're being mentored to, and we might not realize it. Over the period, the practice areas haven't changed that much for me. Now, the percentages may go up and down, and what I put in my application would have been based upon the revenue, not necessarily the caseload. Domestic has always been a large part of what I do. Not so much the order of protections, because we don't have, I haven't really gravitated towards doing the orders of protection. I'm familiar with the law. I know that it ideally or historically, the orders of protection come through Chancery Court here. So I would be prepared to handle those. The other areas I feel real comfortable with. I hope that's an answer to your question.
Well, let's just go ahead and get the age issue out there right now. And I mean, I realize they're catching up on you. They're still behind you, but they're nipping at your heels. And just as long as they continue to nip at your heels, that's a positive. You have done this for a long time.
Yes, sir.
You're familiar with the practice in this area.
Yes, sir.
Obviously. Is this your retirement, or are you just looking to slow down?
This is my re-energizing. If I were to be fortunate enough, one, to make it through to the round of 3 and then by some miracle get the appointment, I'm up and running with the campaign. When we were talking Tuesday, I was under the mistaken impression that it was May of next year. It's not, it's March. So we're right on the cusp of forming committees, getting treasurers, and getting into election mode. I mean, it could well be less than a year by the time the appointment comes down. So I'm fully committed to running. If I don't get the appointment, my inclination is to run. Now, obviously, we'd have to see who got the appointment and how they were doing. But my inclination right now is to run. If I didn't, I would be fully supporting whoever the incumbent chancellor was, though.
And this is for all of the applicants out there and whoever decides to run for this office. I'd prefer to see you guys only one time. I also sit on the Registry of Election Finance, which I've said to Ms. Brooks, I don't want to see you because if you don't file your disclosures and do the right reports, you're going to come visit me, and I'm a lot less pleasant over there than I am here. So, and I'm not going to take into account any of the folks that said, oh, I'm going to run as a declaration and you need to go get your treasurer. I think Bill has done that one point in time, years gone by, so we'll just allow it to proceed forward there. All right, so you're not going to use this as your retirement.
No, sir.
This is the newer and better and invigorated
Well,
Mr. Brooks.
it's the invigorated. I don't know about newer or better.
Okay.
I am what I am.
And as we also discussed on that Tuesday, you've talked long and hard with your senior partner in your family.
Absolutely.
Okay.
I don't want the stink eye from her.
No, you don't want to get the stink eye from Mrs. And you were very, very open in our discussion who calls most of the shots, but this is one of those that you both discussed at long and at length over.
Absolutely. I mean,
And she's fully committed.
she is
don't-
fully committed. She'll be up here and slap me if she's not, but we've
Oh,
talked
yeah,
about
I
it.
picked that up a few minutes ago when we were back there talking, so. Now, you've had generally a chancery practice.
Yes.
You've had a number of jury trials, 25, 30, some odd, over the years.
Yes.
How that was to help you out a little bit. And you've also handled a number of appellate cases over the
yes.
years. We've already discussed one of those cases that you had that was memorable in your past that we're not going to discuss now.
No need to.
But are there any of those cases that you listed in your application that you want to, and I just want you to pick one of them, as long as it's not number two. I think it was
Is
number
that,
two.
is that the infamous Koch case?
That just jumps out at you as maybe, just maybe, the trial court could have gotten that one wrong, and what would I have done differently? And I didn't throw that question to you before,
That's
but I
true.
wanted to do it to you this time.
All right. It would have to be the very first appeal that I was involved in, because it was a workers' compensation case that did involve co-workers' pneumoconiosis or whatever, and the trial court could very easily have gotten that wrong. We were facing what they call an A reader. This is a type of radiologist that has some kind of special designation by the Department of Labor. And we just had a lung doctor. And the trial court could very easily have gone that direction. They ruled for us. Obviously, it was appealed. But I'm proud to say we had it upheld, because it went straight to the Supreme Court at that time. And it was upheld, and I was extremely relieved, first of all, but extremely proud of the way we prepared and handled that case, and the proof that was necessary to get Judge McMurray at that time was our circuit judge to rule in our favor.
Well, trial judges and trial courts now have to submit orders, findings of facts, conclusions of law, and the like. And then they get graded by people like our esteemed chair was for many, many years. How do you consider yourself as a writer?
I have had way more practice writing briefs than I would like. So I feel confident that I can communicate clearly, briefly, and directly what needs to be there in the order, the findings. You know, that the findings, of course, are going to be guided a lot by the elements of the case. If it's a domestic case and it's custody, there's going to be those elements that you rely upon that you're going to need to make written findings about in your order. If it's an adoption case, you've got to do the very same thing. So it might take me several drafts, but I would be able to, I think, get the point made clearly and concisely.
If you hear a domestic case, and now I'm clearly out of my comfort zone, I'm sure Mr. McCarter will correct me if I get it wrong, but if you're looking down at husband and wife,
Mhm.
soon to be ex-husband and ex-wife, and you've got to explain why you may make a decision on division of assets and who has the kids and who's going to get the house and all that other stuff. And you're having to, and they may be living in your community. They may go to your church. Is that going to cause you a problem to look them in the eye as some people have a problem with?
I wouldn't, I mean, obviously, you're going to think about that. I don't believe I would have a problem, and I'll tell you why. Morgan County is kind of a small community, about 17,000 folks. And several times, many times, you know, I have been in court with somebody I know on the other side of a case. And if, you know, I try to treat them with respect, you know, be, you know, direct with them or whatever, and say, look, it's not, you know, it's nothing personal. This is, you know, of course, as a lawyer, you're an advocate for your client, but you're also advocate for the law. You may not agree with the position I took, but here are the reasons why. It's nothing against you, and I think I would be able to do the same thing with the parties that came in front of me in a divorce case, in a termination of parental rights case, or, you know, a boundary line case, or a right-of-way case. Those things a lot of times can be more explosive than a divorce, but I believe I certainly would follow the law. I certainly would explain my decision, and hopefully I would have treated everybody with respect, exhibited a good demeanor, and while they may not agree with what I've done, maybe they would respect it. Certainly I would hope, although I couldn't control it, that they didn't think it was an injustice. They might, but it would have, certainly I think they would have had their day in court. I would see to that.
Now, you and I discussed the BPR,
Yes.
and there were 3 items listed, which
Mhm.
probably worried you to death, knowing you after we've talked, and not just fear of getting the letter, but just something weighing on your mind. Is there anything in particular, those 3, because they were all 3 dismissed?
That's correct.
And we did discuss that, and I think there was the last one.
Yes, the most recent one was a juvenile custody case, I believe.
Yes, I believe it was. Ms. Hardy?
That's right. The
Yeah.
first 2 matters. One was it was a criminal defendant, and honestly, you know, if he was going to file something, he probably should have filed ineffective assistance of counsel, because there was, as far as I recall, there was certainly no breach of any component of the board of the Code of Professional Conduct. The second one, Mr. Todd, honestly, he was not a client of mine, and I can't recall now if it was where I represented his spouse in a divorce or where we foreclosed on property he owned. It could have been either. But nevertheless, that brings us to Hardy. That was a particular, it was a tough case. There had been a child killed by a boyfriend, and the particular child we were litigating over was a sibling, and Mr. and Ms. Hardy were trying to get custody. The child was in the Department of Children's Services legal custody at that time, and it just seemed like anything we did they were suspicious of. They didn't like the judge, Judge Davis, he recused himself, and we went to Judge Burnett. And as I told you, I think they were perhaps more interested in just burning down the system than getting to a result. I don't know, because the case never really finalized. I got out of it. I can't remember if it was at their request or because they didn't show up at a hearing. And then, you know, as I told you, I wasn't surprised that the complaint came. I wasn't alone. I was in pretty good company. About every attorney plus the judges that were involved in it, I think, were complained about as well. You never, there's probably three things you fear in the world. I do as a lawyer. One is that certified letter you get from the Board of Responsibility. You just never get used to that. But it ended up being dismissed. We went back and forth some with counsel for the BPR, and that was it. And I haven't heard any more since then. And we were running up against the time limit on our application, and we just dumped what we got from the board into our application. So it's what you see there is what they have.
We really haven't focused a lot on what I refer to as activist judges, which in some areas it's not as prevalent as it is in others. How do you view yourself? Are you an activist judge?
I'm not. I would not be an activist judge. We go back to our 9th grade civics class. There's 3 branches of government, and the legislature makes the law. Well, we may, as a judge, have some interpretation. We're bound by the law, and I'm not out looking to create law or controversy. The role of a judge is try to eliminate the controversy, or at least resolve the case based on the law, and that's exactly what I would do.
We've alluded to the point, and you've already mentioned it, that primaries in March of next year.
That's right.
And you're ready to start moving forward.
Yes, sir, I am. The gentleman I've talked to that I would ask to help me run the campaign is the one that said, hey, I think this primary is actually March, not May. So,
Did you tell him he's personally responsible for anything that gets wrong, that he'll get fined? Just want to make sure you're full disclosing to this.
Yeah.
Okay. So it is your plan to run.
Absolutely.
Now, I think you have one adult son.
Yes.
And he's over in that big city of Knoxville, I believe, isn't he?
That's correct.
Okay.
Despite my best efforts to get him to.
That was for his benefit,
Yeah.
oh, by the way.
Well, he's in that.
$1.
Well, he's
High
in
dollar
that,
big city.
he's in that conglomeration known as Hardin Valley. That's.
It's more northern Chattanooga, let's be honest.
Oh, Lord. I've learned a lot coming over here about geography. Well, let's take now the problem that, say, Mr. McCarter and I have. He comes over from the now large secondary metropolis in Middle Tennessee known as the borough, and I come in from the Socialist Republic. Am I going to have a difficult time in normal America coming into your courtroom if, say one of the trucks slows me down, it seems like every time I come over here, to one of your motion docket days?
You wouldn't. My hope would be you don't get behind a log truck coming over, because they generally run the roads around here. No, I would hope that when you or Mr. McCarter come to, it's not my court, it's the court of the people of Anderson County. I've just been entrusted, or whoever gets this nomination has just been entrusted with the care of that court. I would hope we've had a conversation beforehand, that introductions have been made, that we all know a little bit about each other. Things happen, I understand that. I know that because it happens to me, and you have a difficult time getting to court. Their cell phones, you call the clerk, or you call the judge's secretary. You're not, as someone that's gotten the stink eye from judges, I learned that lesson long ago. And you just just communicate with the clerk. Just say, look, hey, I got behind this or that, and I'll be along, but I'm gonna be a few minutes late. It shouldn't be an issue.
Now, and we discussed this in part, you've had a couple staff members that have been working with you for 3 decades.
And that's, my former partner and my staff is the reason I've been able to stay in one place for 37 years.
Which is unheard of. Do you foresee any issues if you were to come out of this commission, and if you were to be fortunate enough to have Governor Lee select you to fill this slot, with keeping the folks that are in the office? Because you know that they've got to be worried what's going on in here, and I'm sure they're either watching on the screens or trying to figure out, ooh, have I made that lawyer mad? And I'm looking out now at everybody out here. You don't have that ability. We do up here. And are they wondering what type of person, and is he going to be the tyrant that we think he's going to be?
I guess you'd have to ask them to be sure, but I would think they would say I'm not a tyrant. If they would, I don't think they would have stayed with me or put up with me or James Frank for that matter for 30 years and I may not be answering your question.
No, you are. You are.
We must be doing something right to keep the staff around that we have for that period of time. The same staff, we have the same staff we have when Mr. Pellizzari started practicing and would occasionally come to Morgan County. It's no changes. Their ability to run that office and keep me straight is a credit to them. They're tremendous. They are tremendous.
We also discussed the 21st century and computers and bringing the courts into today. And with a budget of, unfortunately, when Bill Koch was trying to do it in Memphis, he didn't have a $37 million budget line for electronic filings. And we did talk about that for a little bit. Tell me what your philosophy and how you look at the future and electronic filing and things that since I'm in the federal system, I'm used to seeing going through PACER and what have you.
Of course, we know Anderson County and a lot of the other courts around in the 2 adjoining districts scan everything in already, which is a boom for me, because if I have an Anderson County case, I can call up Mr. Cousins' office, and I mean just like that. They can email to you any document you need. Same with our clerk in Morgan County and Roane County and in other places. Electronic filing's coming. It's not here yet. It's not something that I think as a Chancery Court judge by myself should be mandated, I'll say it that way, because you've got Judge Spitzer, and he may have his own opinion about how and if it should be implemented. You've got Mr. Lynch, who's the circuit court clerk. He's going to weigh in, and of course the clerk and master, Hal Cousins. You need to be all on board, 1, and 2. You probably ought to have one system for both courts, so that you don't have a conflict in the technology or whatever. And I've run into this a little bit, not with electronic filing, but with the title work we do. There's 2 different platforms for doing computer researching. Our county is on one system. Roane County, Fentress County is on a different system, and then Anderson County has its own. So you got to go to 3 different places if you want to, depending on where you're searching. You can't just go to one, to Title Searcher, and pull up everything you need. You got to go to Title Searcher, U.S. Title, or the Anderson County website, which I kind of wish everybody followed the Anderson County website, because it's fantastic. It was really the first one around here. you know, for what it's worth, I'll just throw this in here. We've had technology around here since as long as I can remember. It started with Judge Meredith in trial justice court when he'd come in and pop on his tape recorder every time court started, where he had this spiel about the rights of defendants in criminal cases. And that was the first exposure I had to that kind of technology in court. That was quite an experience.
Wow. Steer clear of that. Is there anything that you want to jump out and say that I haven't already gone over from what we talked about?
Kind of from the school, the less said, the better.
Understood that. I'm sure that some of my fellow members will have some tougher questions for you. I mean, I thoroughly enjoyed our conversation. I'm going to pay you a compliment that you won't know that is a compliment, but Bill Koch will, because you remind me so much of Ben Cantrell and his whole demeanor and the whole way he was, which is the quintessential chancellor. Well, but I'm saying he was a quintessential chancellor at the time on demeanor. Okay. And if you were looking at Gibson's, his picture would be on the cover. Or I say that instead of C. Allen or some of the older ones. But with that, I'm going to turn it over, my time back over to the chairman to allow him to proceed forward.
Well, I'm going to recognize Mr. Waters.
What's Gilbert's?
Oh, don't do that to me.
Hey, thank you for coming today. I only have a couple little notes. I appreciate that part of your practice is being a dirt lawyer. I think, I really appreciate that. I know what title searcher is, and I know your frustrations with finding things in different counties. It's not always fun. But you mentioned that you're a man with no country, and I think that can play in your favor here. Are there portions of other courts or other chancellors that you've been in front of that you think you would bring those changes to Anderson County?
I can think of one thing, and I don't know exactly how it would work here. Yeah, out in the 9th District, we have docket sounding once a quarter. And I don't think that's the way Chancellor Lantrip or Chancellor Cantrell necessarily handled things. They probably had set it by status conference and things like that. But, we've been without a chancellor essentially since November. I understand that she did, hold court quite a bit in January, but there's a backlog. And it may be that let's get, I don't know all the logistics of what it would take for Mr. Cousins to send out the notice of docket sounding, perhaps by email. Let's get the attorneys in and let's go through the cases and see, we're going to have some stale ones. Are those things we can get rid of? We're going to have some that are moving along but aren't ready for trial. Or we're going to have some that, they need to get heard. And then you've got laid over that, you've got termination of parental rights cases, and they're on a short timetable. They need to be heard, I think, within a year of filing. So you might have to jockey around with the docket a little bit. So that's one thing I thought of. Now, I've practiced in this district for 37 years. I don't recall ever coming to a chancery docket sounding. That would probably be the one thing that I might like to do, try to do, just to get a handle on the docket and see, what can we dispose of immediately, what, take care of it that way.
You mentioned the backlog. Is there, I know this issue's come up before, but are you comfortable ruling from the bench, or are you more of a take it under advisement, rule later type of judge? What do you envision for yourself?
I think, Mr. Waters, it would be ruling from the bench. I would like to think I'd take good notes, that I would, have the elements, the areas that you need to make the findings of fact in, and be willing and able to do that at that point. The people that come to court, they want to know an answer. They don't want you to take it under advisement for 10 minutes or 10 days or 30 days. So every time possible, that's what you want to do. And that's the way the chancellor in the 9th district did it. That's what limited experience I had with Chancellor Neal and then later Chancellor Thurman out in the 13th district, which is Cumberland County. That's the way they would do things. Chancellor White up in the 8th district. That's what I'm used to. I'm used to, you get immediate feedback, and then you go deal with your client if it's not going your way.
Well, I have no further questions.
Thank
Thank
you.
you again for your application.
You're welcome.
Thank you, Mr. Chairman, and thank you, Mr. Brooks, for your application. Like others here today, you're eminently qualified
I appreciate you saying
be a
that.
candidate for this position. So we always have good candidates when we come to Anderson County, and
You got
and
really
that's a-
good
that's a
candidates
credit.
today.
Just a couple of quick things. Are you a worrier? Do you consider yourself to be a worrier?
You might better ask my wife that. Somewhat. I mean, I do worry. I mean, like most people, I can tell you that if I think I was asked, or Ms. Crutchfield was asked about a 3 a.m. search warrant. Well, since I filed this application in getting ready for this interview, I guarantee you I probably would have been up at 3 a.m. worrying about this. So, I mean, I do worry.
But it wouldn't impede you from making decisive decisions as a chancellor.
You've got to make decisive decisions. That's why you're put on the bench. The people that come before you, they count on that. The case is important to them. I mean, whether it's a pro se uncontested divorce or the most complicated contract case, it's important to them, and they're there because they want a decision, and they're looking to you to make it, and that's the responsibility of the court.
Sure. And I'm not saying that as criticism. I mean, I'm a
Understand.
bit of a worrier myself, but I have got past that since I retired. Let me go to the search warrant question. Normally, law enforcement does not seek out a chancellor
Right.
initially for search warrants or their needs. In a situation that everybody was just out of pocket, and you got that call that the general talked about, you wouldn't have any hesitation in inviting those parties to come by and take it under consideration.
No, sir, I wouldn't. I mean, I feel like I'm not a lot in the criminal system these days. I do have cases pending, and I am familiar with the criminal procedure. I mean, I can look at the affidavit and draw my own conclusion as to whether or not I think it warrants signing of the search warrant. So I feel very comfortable, because you don't know what's presented to you, but I feel competent and comfortable in that scenario.
Sure. One last thing, how do you feel about the death penalty?
I have been listening back there. There is a place for the death penalty. Has been, is, and will be going forward. Thankfully, there are a lot of procedures, protections in place, but also, if there is that sentence handed down, it needs to be carried out. So I don't have a problem with the death penalty. It's highly unlikely something like that would come in front of a chancellor in this county. But if the facts supported it and the law permitted it and the jury found it, I would have no hesitation. I'm not going to, unless I think there's some injustice, I'm not going to substitute my opinion for what this jury has sat there and heard and done.
All right, thank you, sir.
You're
Thank you, Mr. Chairman.
Thank you. Mr. North?
Good afternoon, Mr. Brooks.
Good afternoon.
Mr. Lawless had asked you about the domestic relations practice and the court dealing with the domestic relations caseload. In my neck of the woods, orders of protection and DCS referrals have become, shall we say, weaponized.
Mhm.
And that's absolutely, totally, indescribably despicable. How would Chancellor Brooks deal with that? You've got somebody coming in asserting abuse of a child and wanting an order of protection or a DCS referral or something like that. How would you deal with that on the bench?
I would like to think, Mr. North, that because I've seen how people deal with each other over 37 years, I could listen to them and get some idea of whether there is a speck of truth to this, or if it is, as you say, being weaponized, because that happens a lot. For whatever, well, I think one of the reasons is they want to get leverage on one side or the other. But I feel like, at least with the order of protection area, I would count on my dealings with the public clients over the last 37 years and do my best to weed out what I thought was not supported by the law or the facts and was a weaponization. Now, referrals from DCS, I'm not sure exactly what you mean by that. Are you talking about where maybe they have filed a petition and taken a child into
Right,
custody?
complaint to DCS for abuse.
May not get involved in that initially until the aggrieved parent, I guess, can come and request a hearing. Maybe that's what you're referring to, or whatever. Again, I mean, unfortunately, I've seen abuse of that. I think you just you have to go back and rely on on your life experience. Maybe that's probably not the correct term, but just what you know about human nature, and listen to the facts, and judge them against your common sense, and to see if something's supported. I think if it's a parent versus DCS, I think you probably have a higher burden of proof that DCS has to come up with, clear and convincing evidence versus a preponderance of the evidence. So you got to take that into consideration as well. But when you are in the domestic arena as a judge, the best interest of that child has got to be paramount. When you're an attorney, you're in there advocating for one side or the other, but again, your role as a judge is different. You're looking out for is not the right term, but you're looking to the best interest of that child, if that's a response to your question.
I think it's a good answer.
Thank you.
Are you prepared to run a contested election if you're chosen by the governor?
Yes,
Are you prepared to
yes,
run
I am, Mr. North. I have spoken, and I have someone lined up to kind of manage it for me, because I've never run an election before. That would be disaster if I tried to do it. But I would let those that know what they're doing, help me. I mean, I'm not going to lose control over it, because you don't want all kinds of wild things being said. This is a judicial race. But yes, I'm prepared to run.
Will you run if not chosen?
My inclination is yes. I have a lot of respect for the governor, and I think he'll get it right no matter, but you don't know. I mean, right now my inclination would be yes, and if I did run, it wouldn't necessarily be against whoever's appointed, but it would be because I think I could still do a better job. And if I didn't run, it would be fully supportive of whoever the incumbent or the sitting chancellor is, because you've got some excellent folks here to choose from. But I kind of come back to what I said earlier. I feel like my experience, and you'd have to ask others this, but I feel like my demeanor is such that I could do a good job and do the office honor, and you kind of go back to the preamble to the Code of Judicial Conduct: integrity, competence. I think I would bring all that to the office.
As Mr. Lawless also pointed out, you're not a spring chicken, but you're 4 years younger than I am, so.
I wasn't gonna mention that.
Would you be inclined to finish out, once you're elected, finish out the remaining term?
Oh,
Or run
yes.
another term, or what?
Certainly. I'm in this to finish it, at least through 30. I'd be 70 at that point. I'd have to see what my health is. My health is I'm in good health. Now, I don't go to the gym as much as my wife wants me to, but we're working on changing that. But I'm in good health. I don't foresee any difficulty. I think my mind is in good shape. But I certainly intend to finish out the term and may seek reelection.
And that would be a 6-year term that you?
Yeah, I
basically-
think, I believe Chancellor Chancery was elected in '22. Whoever gets this appointment is going to stand for election next year in '24, and I think that's going to be to fill out till 30. That'll be the next cycle for a judge. That'll be 6 years, 8 years total.
Thank you for participating in this process.
Thank
Mr.
you.
Brooks.
And
If I
kind
could
of,
just-
you've
if I
given
could
me
just
two opportunities to throw this softball to me. Maybe I'll, my hero was Ronald Reagan. And I think back to 1984 and the debate. Y'all know where I'm going with this. I wouldn't want you to look at the youth and inexperience of the other applicants and hold that against them. That's,
Before the
that's
time
probably
gets
the-
passed to general helper, I have some good news for you. There's life after 75. Just
I hope I get there. I hope Mr. Brooks and
yeah, I
I
do
get
too.
I ain't that far from it, and I hope to get there.
Yeah, I hope you're there waiting on me when I arrive.
I appreciate your application. I have no questions. so-
Thank you.
You're going to get my first question of the day.
Oh, boy.
Have you made the comment that if you were not appointed, that you might still run because you think you could do a better job?
Yes, ma'am.
Everybody has been very impressive today.
Oh,
So what makes you think you would do a better job?
what makes me think I would do a better job is, privately, I have sat in the courtrooms that I've been in, the Chancery courtrooms over the years, and there's a lot of downtime if you're not the first case. And I would listen, and I would think, okay, this is how I would rule, and then I'll see what the Chancellor actually does. And about 50% of the time I'll get it right. But because of that experience, and because the multitude of judges I've been in front of, and I've learned something from every one of them, it's important that you have extensive trial practice. I think it's even more focused that you've had extensive Chancery practice, that's domestic, real property. And I think, excellent candidates, as you said. But I feel like, or I believe, that's my wheelhouse. That's where I've got the experience, and that would be the reason. I feel like I could contribute.
Thank you.
You're
I have
welcome.
no more questions.
Mr. Lang?
Thank you for your application. I just wanted to make a comment, no questions, but this process that all of us have signed on to be a part of, and you all put your names out. If people don't apply, this process doesn't work. So I just want to give this judicial district kudos for having such fine candidates put themselves up for this sort of process, and thank you very
It's a-
much for
it's
your
a-
application.
It's a very good bar association here. I'm not technically part of it, but the attorneys, we see each other here, Morgan County, Roane County, different places, so it's an excellent bar, and I've been reminded of that this morning.
Thank you.
Mr. McCarty?
I want to make a comment that, Mr. Nord, you look great for your age.
I'm feeling okay.
You know, the great thing about Mr. Lawless is he's thorough. I guess that's with running a federal practice. I don't even want anybody to say federal court to me. It makes my head hurt. He did a great job. my uncle reached out to me, and evidently he was a classmate of yours, and you and he have had some run-ins over your careers, and he really said a lot of fine and kind things. He's my best friend, so that meant a lot to me, and so I appreciated that. Some of the things he said about you, integrity, just an all-around great guy, very, very competent. Some of the things that he shared with me about you, so I just wanted to share that with you.
Well, I appreciate that. Again, that law school world, mine was A through H. Robert Hinton's the H. Tremendous, lucky enough to encounter him every once in a while. He's over in Lenoir City because that's part of the 9th District. We see each other occasionally. Great guy. Great guy.
I appreciated your application. You did a great job. I'm pretty certain you won't give anybody stink eye, so I appreciate
That's the
it.
acid test.
Yeah.
Thank you. Mr. Wallace paid you a very high compliment when he likened you to Ben Cantrell. His nickname on the bench was Gentle Ben. There are a couple of things that I spent a lot of time practicing in front of you. Get your reaction as if you were chancellor. Obviously we didn't have juries, so we'd have a lot of bench trials.
Yes.
And when evidentiary questions would come up, somebody would stand up and say, Your Honor, that's inadmissible. And he'd look very kindly and say, we're going to let that in for whatever it's worth. Now, how are you on the rules of evidence?
I wish that was one of the rules.
Well, I know. Well, it was in Davidson Part 1.
Obviously, the rules control. Do I study them every day? No. Am I up on them? Yes. I think I can spot and pigeonhole it into one of the rules, or if it's hearsay, one of the exceptions, if necessary. I'm confident of my ability to handle the rules of evidence.
So it's not a rules of evidence free zone in your court.
No, it's not been suspended. Will not be suspended in the Chancery Court of Anderson County. No.
Well, and another thing, I'm not hanging this on Ben Cantrell, but I've been in a whole lot of Chancery courts, and there's a saying, you may be familiar with the term, you may have used the term. There's one or two ways to say it. It's either the equity pitcher or the equity bucket. Where we're, quote, we're going to do the right thing, we're just going to dump some equity on this. How do you think about the equity bucket?
Well, Chancery Court historically was the court of equity.
Yeah.
But we are governed by the rules of law. And you're governed by the rules of law. You may be sitting up there salivating, please give me something to hang my hat on. But it comes back to the law. And that's because it's got to be fair to everyone. And, that's my simplistic way, I guess, of looking at it.
And let me ask you one final, this is more of a process question than anything else. If I were on the trial bench, I know I'm going to be really busy. And there are going to be times when I'm going to have to make findings of fact and conclusions of law, and I may want to do that from the bench, as you say, deliver extemporaneous opinions. And I guess what you're going to do in that circumstance is that the court reporter is going to take down what you say, and perfectly fine. Let's assume for a minute that you're either going to want to take it under advisement, or, and again, this may not be a practice up here, but there are a whole lot of Chancery courts around the state that say, well, why don't y'all, both of you, prepare proposed orders and send them in. And what do you, that may go on up here, it may not, and I'm not being critical of it.
No.
But how would you handle that kind of situation where you're seeking, rather than saying the prevailing party will prepare it?
Right.
Both.
In our district, in the 9th District, Chancellor Williams wanted everything put into the order. He did not want just a transcript of his ruling attached to it. So he would charge the lawyers with writing up the order with the findings of fact. Sometimes you can get by with, referring back to the court reporter if you don't, as a judge, have good notes or whatever. But you're the one, as a judge, you are making those findings, and I guess it needs to be your word. So in my case, I would hope, or I would rely upon an efficient assistant. As I use the hunt, peck, and cuss method of typing. I should not be doing it, but I think that would be the key, because you certainly, you're under an obligation to get that opinion out if you do take it under advisement. Now, you may make an announcement from the bench so the parties know, but a lot of times, to protect the parties and yourself on appeal, you're going to need to make those findings, and they need to be your findings.
Exactly. Well, that's very helpful. Thank you very much.
You're welcome.
We are at the end of our hearings, and so under our rules, we will now immediately vote. And I'm reminding my...
Go through the litany. It's been so long since we've
Well,
done
you've probably forgotten it. Today, we are using blue ballots. Please take one blue ballot out. In the upper left, voting round, write number 1. And then you will notice that there are 6 boxes. We are crossing one out. There are 5 people we are electing. And as Mr. Lawless has always reminded us, don't vote for 1, don't vote for 2. You must vote for 3 in order for your ballot to be counted. And as I told you all initially, if on the first round 3 people receive 6 or more votes, our job will be finished. We will announce the results, and those votes will go to the governor. If less than 3 get 6 votes, we will have a second round of voting after we take a brief recess. And the way our protocol works there is, obviously, the two people who have been selected, or the one person who has been selected, will not be voted on for the second round. The person receiving the fewest votes will drop off, and the second round will be for the remainder. So I just wanted you to know how this will work. So if you're prepared to vote, mark your ballots. Our secretary will pick them up, and our staff will count them, and we will tabulate them. And while it's being tabulated, this usually takes a few minutes. Please feel free to get up and move around.
Mr. Chairman, if I can say this, I am incredibly impressed with the pool we had today, and that's a compliment to these. You guys are great. You really, really are. It's astounding.
We're just missing. Here, I've got it. Coming for it. Thank you.
Yep, you got them all?
I was really excited about fireworks today, and
was just a different trend than we had seen. Probably add across, right? That's our check.
The jury is back. And first, again, let me thank you all for applying. And I'm not trying to prolong the agony here, but no matter how the outcome is, we all, talking among ourselves, we'd like to practice up here. I know it's not perfect, but it sounds pretty darn good. So again, thank you all. Before we disperse, remember, please give the staff back the blue ballots so you can't stuff the ballot box another time. But this was a full and fair election, and I'm going to read the names selected in alphabetical order that will go to the governor. We have a selection on the first round. Jamie Brooks, Karen Crutchfield, and Daniel Forrester. Congratulations to the three of you and best wishes. And for the other applicants, thank you again for applying, and we wish you well. So is there a motion to adjourn? Second?
Motion to second.
Say aye.
Aye.
We are adjourned.
Out the door too fast.
Yes, yes. So don't knock me over on the way out.